To continue with assignment, if the assignment of rights is valid, and we'll talk just a minute what we need to have a valid assignment of rights. If the assignment of rights is valid, the assignee stands in the shoes of the assignor. So if I were to assign my rights to you to receive money from another party, you would have the same rights as I do to enforce that contract against the other side. So again, if you look at that chart on the bottom of page 159 in the textbook, that's what that chart is showing when it has that perforated line going from assignee up to the debtor or obligor. That's showing that they have the right to enforce the rights under that contract that have been assigned to them. Okay. Once I assign my rights to you, my rights are then extinguished. Okay, so this is an important thing to understand because when we talk about delegation in a little bit, that acts a little bit differently. But in a valid assignment, when I assign my rights to you or to whoever, the other party that's not originally part of the contract, my rights are then extinguished. So if I give you the right to receive... And there we go with our first interruption. I'm sorry about that. So anyway, with an assignment of rights, once I assign my rights to the assignee, so I say I assign my rights to you, I no longer have the right to enforce that contract against the other party. Only you have the right to enforce that contract against the other party. So when it says that the assignee stands in the shoes of the assignor, that means you take over all my rights under that contract, or at least those rights that I have in fact assigned to you. So you then, even though you are not an original party to the contract, you could then file a lawsuit in court to enforce that contract against the other party. And that's what a valid assignment will do. So then the next question is, how do you validly assign rights? So what is important is notice. The notice of assignment is important. That is key to having a valid assignment. When an assignment of rights occurs, the party assigning the rights, the assignor, has to give notice to the other party of the assignment. Okay. So if I'm in a contract with you and I am assigning my rights to Joe, I have to give you notice that I am assigning my rights to Joe and that the performance of their part of the contract needs to be rendered to Joe, the assignee. Okay. Generally, as long as I give you... Again, okay, so it's a nice day and everybody has decided on a late Sunday afternoon that they're all going to walk their dogs past my house. So again, I apologize. So notice is the key. So as long as I give proper notice to you, then the assignee stands in my shoes, essentially takes my place under the contract insofar as enforcing the rights I have under the contract. So the notice is key. So if we are assisting a client with a notice, we would obviously do it in writing. We would send it to the other party. We would make sure we had documentation of it. But generally, no official format is required. If you are assigning rights to a contract that has to be in writing under the statute of frauds, then the assignment should also be in writing pursuant to the statute of frauds. But beyond that, the law does not require any particular format or method of notification. It's just that notification has to be made to the other party. If I were to assign my rights to Joe, but I didn't give you, the other party to the contract, notice, then you could render performance to me. You could go ahead and pay me, and you would have no issues with that because that's what the contract says to do. So the notice is what makes the assignment a valid assignment. But again, if I give you notice and you either fail to perform under the contract, the assignee can pursue you for enforcement of the contract, or if I give you notice of the assignment and you continue to render performance to me, the assignee can still go after you to enforce the contract. So again, that notice is really, really important, and that's what makes a valid assignment. And again, that's assuming that it is a contract that is assignable to begin with and not one of the ones we've already talked about. Okay, so can we avoid an assignment of rights? Because generally how the law is going to view assignment is, unless it falls under one of those categories of contracts that we've already talked about, or unless we do one of these two things listed here, the contract can be assigned. So if we are entering into a contract or drafting a contract on behalf of a client, this would be something we would ask them. Do they want to avoid assignment? And there's two different ways you can do that. One is through an anti-assignment clause. Okay, so an anti-assignment clause in a contract is a clause that literally just states that the contract cannot be assigned. So if we are drafting a contract on behalf of a client and they do not want the rights under a contract to be assigned, we would just include an anti-assignment clause, which could be as simple as saying something to the effect that neither party can assign their rights under this contract. The other option, which can be sometimes part of an anti-assignment clause, would be an approval clause. An approval clause would be a statement, a term in a contract that would state that the assignment can only be done with the approval of the other party. So if we had an approval clause in our contract and I wanted to assign my rights to Joe, I would have to get your approval of that before it would be a valid assignment. Okay, so those would be the two ways, having an anti-assignment clause or an approval clause in the contract to begin with. If somebody comes into our office and the contract is silent on assignment, the law is going to presume the rights can be assigned unless it's one of those contracts that we already talked about, like a personal services contract. The other issue that sometimes comes up is when you have successive assignment of a right. So this is a situation where I assign my rights to Joe, and Joe then assigns his rights to Lucy. Okay, that's a successive assignment. It's all the same right, but I first give it to Joe, Joe then gives it to Lucy. How does that work then? Who has the right to enforce the contract? So basically, what you're responsible for knowing is the American rule that's at the top of page 163 that provides the first assignment in time prevails regardless of notice. So what that means is Joe would have the superior right, so to speak, to enforce the contract because his was the first assignment. Lucy was the second assignment. So Lucy would not have a right to enforce that contract unless somehow Joe failed to do that. So usually, and I can't really think of a legal situation or a case where we would want to advise a client to assign a right again or to be on the receiving end of an assignment where they're not the first assignee. But if that was to happen, that is the rule that we would be following. Okay, so that is assignment. We assign rights under the contract, and rights are what we are owed under the contract. That is different than the delegation of duties. So again, assignment of right is something we are owed. We have a right to something. We're assigning that right to someone else. A delegation of duty is our obligation to perform. What are we supposed to give under the contract? So to kind of put it into terms of how we've talked about things before, in an exchange of benefits and detriment, the benefit is our right that we can assign. The detriment is our performance. That would be a delegation. If we are going to transfer our duty, our obligation to perform, that is called a delegation. So assignment and delegation, even though they seem so similar, they are very different concepts, and legally they mean different things. So you need to be clear on that. And they don't act exactly the same either. So you just need to learn them very separately and distinctly. And I guarantee you in any test question, it would ask about assignment or would ask about delegation. It wouldn't lump them together in one question, just so it would be very clear to you. So again, terminology for assignment, we had assignment, assignor, or assignee. In delegation, we have delegation, the transfer of the duties under the contract by the party who has the obligation to perform to someone else. The delegator or delegator would be the person who's transferring the duty, and the delegatee or the delegate, and both terms get used, the party to whom the duty has been transferred. So again, you and I are are parties to a contract. I am going to sell you my car for $1,000. My duty is to provide you with my car. If I'm going to delegate that duty to someone else, I would become the delegator, and then the person I'm giving that duty to would be the delegate or the delegatee. Okay. And that example is a little weird for that scenario, but that's technically how the terminology would work. So in the textbook, at the top of page 164, they have another little chart that, again, I think sometimes the visual with this can be a little helpful. And so they give the obligee and the obligor at the top of the chart. So the obligor, in this scenario, me, I am going to delegate my duty to Joe, the delegate. And then you, the other party to the contract, can be called the obligee or the promisee. Okay. So once I delegate my duty to someone else, again, you and I have privity of contract, but now I have appropriately brought someone else into this contract and has the right and the obligation to perform under it because of my proper delegation. So just like assignment, unless the parties otherwise agree, parties can transfer the performance of their duties to another person. The exceptions, and here they should look somewhat similar to you. Personal services contract. So again, if I'm hiring someone for their particular skill, knowledge, style, expertise, generally those obligations cannot be delegated to someone else. And if the performance would materially vary if the duties were delegated. So the example for that I think is somewhere in the textbook, but I always use as an example as well. If I am going in to have my gallbladder removed, and the surgeon delegates his obligation to remove my gallbladder to a podiatrist, that's not going to be an appropriate delegation because the foot doctor, podiatrist, not a medical doctor, not a surgeon, not trained, that performance would materially vary by that delegation. It would just be potentially malpractice too, but that's a whole other issue. So that's an example of how the person doing it may not fall under the first exception, but if it would materially vary the performance depending on who was actually performing, then generally that cannot be delegated either. Okay, so with the delegation of duties, a couple other similar but yet different things to assignment is if it is a valid delegation, the delegator, me in our scenarios, I remain liable for performance. Okay, so this is where it's very different from an assignment. If I assign my right, I am removed from that contract basically, and the assignee stands in my shoes, so to speak, assuming it is a valid assignment. For a delegation, as the delegator, I am still a party to that contract. So it doesn't get me out of the contract completely by delegating my duties. And I will pick up with that concept in the next video.